So, boy, you guys have been such close friends of mine for so long, but I'm going to start with Rick because I actually met you first. When I was a baby public defender, I go to training at the Lake of the Ozarks, and Rick Kamen was my teacher. I don't remember if you did opening or closing or cross or what you did, but you did a beautiful presentation. You were on the faculty at NCDC. And fast forward 4 years, I'm at the Jerry Spence Trial Lawyers College, and we're classmates for 3 weeks of our lives. Thank you for doing this, Rick. Rick's a lawyer in Indiana. NCDC, you're still on the faculty there, is that right?
Yes.
And you're on the faculty at Trial Lawyers College. And Rosa, I met you also in October of 2000, the same class. All three of us were at the Jerry Spence Trial Lawyers College for 3 weeks of our lives in the mountains of Wyoming in October. So it was very cold, I remember. And Rosa's also on the faculty of the Trial Lawyers College. And you're both here today because you both had the experience, and I believe, Rick, you're the reason Rosa had this experience. I think you recruited her. You both had the experience of working, well, representing people who were accused terrorists. They were housed at Guantanamo Bay, and there was a great big scandal. I remember reading about it and seeing news stories about it, of allegedly the prosecutor's office recording attorney-client meetings. Did I get that right?
Well, somebody, we have to choose our words carefully because there's still classification issues, but, and I'm using the words of the DC Circuit Court of Appeals, microphones were found in the area where we met with our client. We were never able to determine, because the judge wouldn't have a hearing, who put the microphones there, how long they've been there.
Who found them?
Rosa, you want to answer that?
Actually, it was myself and our investigator. We were allowed to inspect the area where our attorney meetings were taking place. So upon inspecting those areas, we found a hidden microphone. I think that's also in the opinion, and we could call it that.
Are you able to tell us how you found it? Like, if we lawyers were in a meeting, and we had a scandal, by the way, here in Kansas City with the CCA that holds our federal inmates. They also were recording attorney-client meetings and giving them to the prosecutor's office, and the prosecutor's office was listening to them. So where would we even look? Was it like hidden in the vents or what?
You know, Kim, before I go any further, I forgot I have to clarify for the record that I'm appearing personally, and anything I say does not express or reflect the views of the Department of Defense, the United States government, any agency or instrumentality thereof. So I apologize, I should have said that in the very beginning. But
that's okay, we respect that you have to do that. You're an employee of DOD, aren't you?
yes, so having said that, the recording device was hidden, yes. I don't think I can give the details of where it was hidden, but it was in
What even caused
the attorney meeting rooms.
What even caused you to look? Was there something that
Yes.
spurred that investigation with you and your investigator?
Well, in June of the same year, 2018, we were notified by our by General Baker, who's our chief defense counsel, that based on some information, he was no longer confident about the confidentiality of our attorney-client meeting rooms. So that's what prompted that.
I'll tell you that I'm a former public defender, and a lot of public defenders are on this CLE listening, and some are former public defenders listening. We always, and especially now with COVID, we're really struggling to make sure that we're having private meetings with our clients. Some jails are doing video. Some jails have not allowed contact visits for some time. So this is a huge struggle for a lot of us, especially those who are representing inmates that regularly, like the public defender's office. So I don't envy you, but how do you protect your, I mean, I know there you couldn't because it was hidden and they were somebody was listening on purpose, but how do you do your best to create the perfect environment for an attorney-client meeting?
Well, of course, Guantanamo is its own bizarre universe, and you have very little, even less control over the conditions in which you meet than you would in the typical jail.
Can you
Because,
describe a little bit of that for us, Rick, and give us that understanding of what Guantanamo's like as a lawyer?
well, in terms of the meeting or just in terms of the overall,
Both.
well, in terms of the overall atmosphere, I mean, it would be kind of like going to Sedalia, Missouri with good weather. I mean, it's really not the nicest place in the world. And actually, my wife's family's from Sedalia, and I like it. But you know, Guantanamo looks like a depressed Midwestern city, small town actually. But to be a lawyer there is bizarre on all number of levels because while the court is physically there, very few people associated with the court are there. And so when there's court hearings, everybody is transported there on the same flight. And so you'll have the judge, the prosecutors, the defense lawyers, the press, you know, and again, it's a Department of Defense installation, and then there are various other agencies that are involved. And so you have, you know, they tell you where you can meet.
Were you both there as employees of the DoD assigned to represent accused terrorists?
Well, the way this all happened, I was first recruited by the American Civil Liberties Union, what was called the John Adams Project, to become the death penalty lawyer, learned counsel, for a fellow by the name of Abdel Rahim al-Nashiri, who was charged in the bombing of the USS Cole. My involvement began, I first met with Nashiri in 2008, and I was involved until 2017. I was the lead lawyer. Several years later, my memory is it would have been 13 or 14, we were allowed to hire civilian lawyers, and then our team hired Rosa. So she and I worked together representing Nashiri. Then within everything that happened with the microphones, we both left that case, which was all manner of drama. And in fairness, Rosa has stayed on with the Office of the Chief Defense Counsel, representing another inmate, another detainee who's also facing the death penalty. So that's sort of the overview of my involvement and a little less about Rosa's.
Before
Yeah,
we,
I actually began in 2015, November of 2015, which is almost ironic how important that date was on this case. I think that coincides with some of the investigative information we found on the judges. So,
Rosa, I'm having a little difficulty with your sound. Can you just be closer to your computer?
of course,
Thank you.
I started in November of 2015.
And that's an important date because why?
Well, as the events unfolded in this case, eventually the issue became centered around the judge and his impartiality on the case. So some of the events that led to his impartiality started around November of 2015, where he had been applying for a position as an immigration judge. So that's why I remember those dates. Overlap. So, yeah.
So your guys' experience, I remember, made national news, and I want to talk a little bit about what was happening to you that made the national news.
Well, after we found the hidden microphones, we had we were faced, well, the first thing that happened was we needed to tell our client. Well, actually, let me back up. The first thing that happened is we filed something about the microphones, and the prosecution's response was everything pertaining to this is classified. And it was classified at really the highest possible level. Now, Rosa and I have security clearances, and that's not unusual in Guantanamo that things are classified, but it was unusual that this was classified. And the consequences,
the recording,
the fact of the microphones and any litigation pertaining to that was considered at a higher level than top secret.
Okay.
And so we could not legally tell our client. And so we went to the judge and essentially said, Judge, we need to tell our client that our conversations may not be privileged because he has to make a decision as to whether or not he wants to continue to meet. And the prosecution opposed that because this is classified and he doesn't have access to classified information. And the judge, who, as Rosa alluded to, we found later was pretty ethically compromised, sided with the government. So we couldn't tell the client that, and get a waiver. And then we asked for a hearing so we could know who, what, where, how long, what this was all about, which the judge denied. And so we had a number of discussions in which we really tried to sort out the ethics of all of this. I took it upon myself personally to hire an ethics expert, woman by the name of Ellen Yaroshowski, who's with Hofstra Law School and is one of the leading experts on ethics in criminal defense, and shared with her what we could, because again, the details were classified. And she concluded that under the rules of professional responsibility, we were ethically obligated to withdraw. Now, I'd been Nashiri's lawyer by this time, his lead lawyer, and I was the longest serving lawyer for over 10 years. Rosa had been with the team and very much central to the team for 2 years. There was another lawyer who had been there somewhat longer, who was in essentially the same position because we were all civilians. And so we really had to decide what to do. And ultimately, we concluded that we were obligated to withdraw, and then we had to seek permission of the Chief Defense Counsel, General Baker, who under the rules there was the person to approve or not our request. And he did his own due diligence, and of course he had access to the classified information. And he concluded that, yes, we were obligated to withdraw. Now we knew that this was going to be a mess, that everyone was going to get crazy. And in one of the meetings, one of the other lawyers, as we were gaming through how this was going to work, said, now Rick, you're a learned counsel. Under the rules of Guantanamo, the system's supposed to stop if you're not there. So you've got to accept that there's about a 30% chance you're going to get arrested.
Arrested for trying to withdraw as counsel?
Yeah. Because they had essentially arrested a lawyer, not one of our team, just a witness, who all he wanted to do was testify by video, and they arrested him, hauled him from Boston to Alexandria, held him in jail overnight. I mean,
and he was a lawyer, that witness.
He was a lawyer, and a witness. And I will say that, and I say this not entirely jokingly. I mean, I have said that to clients hundreds of times. But when you hear it and it's real, it takes on a completely different feel.
You're laughing, but that had to be traumatizing.
Well, yeah, it was, you know, I make the joke that I had 3 physical reactions. The first was that, you know, I missed a couple of breaths. I'm sure I missed a couple of heartbeats. And, you know, my sphincter knotted up relatively tightly. And so when when it became clear that, you know, that we filed a notice that we'd withdrawn and the chief defense counsel had approved it, the judge ordered us to come to Guantanamo because they were going to have hearings. He ordered us to come to attend the hearings.
And this is the same judge we know later is compromised with his, he's biased.
But there is a statute that prohibits Americans from being required to go to Guantanamo. And so we said, nope, we're not going to come. And so the next thing that happened was the chief defense counsel, who was in Guantanamo, was ordered to appear and ordered to rescind his order excusing us from the case. He refused and was summarily held in contempt and was ordered essentially to home confinement for 21 days. And then he had to file a writ of habeas corpus in DC to deal with that. And ultimately he was exonerated. The judge then ordered Rosa and the other lawyer, whose name is Mary Spears, and I to go to Virginia, theoretically to represent Nashiri by video. But in reality, as he essentially later admitted, the plan was to order, once we were in Virginia, to order us to come to Guantanamo. And if we refused, he was going to have us locked up and confined in Virginia. We sort of saw that coming, and so we declined to go to Virginia. And I was in Indianapolis. Rosa was in Chicago. Mary lives in Virginia, and so we all had lawyers by this time, and you know, standing by. You know, I filed a petition for habeas corpus in Indiana, and ultimately a judge in Indiana ruled that I could not be arrested by any process issuing from Guantanamo Bay. Rosa and Mary, their lawyers proceeded slightly differently, not wrongly, just differently. And so they were, for the next 2 months, about every month, the judge would have hearings and go on a tirade and threaten to arrest them.
Rosa, you want to speak to that? What it's like? Rick was secure in knowing he's not going to get arrested, and now you're having to do your ethical duty, which the ethics professor, I guess, or the Hofstra, the ethics expert said, you have a duty to tell because you have a duty to tell your client, you're told you can't tell your client, now you have a duty to withdraw, right? Is that essentially where you were at that moment?
Yeah, that's pretty much the analysis of the ethical obligation. And yeah, we were differently situated because we didn't have a federal court order that preempted any of the judge's conduct in trying to have us forcibly brought down. So, you know, I can honestly say that's probably been the most difficult time I've ever experienced as a criminal defense lawyer in all my career. And we all know that being a criminal defense lawyer is not an easy thing in and of itself, but I don't think I've ever had this kind of pressure that I thought that any minute myself would become, well, I became the client, but any minute I could be brought in against my will, arrested, and detained. So
that's scary to be doing your job and to be under that kind of stress.
Very much so. Very much so. And And it's especially when you're trying to do the right thing, and you believe in what you're doing is the right thing.
Yeah.
And at the same time, you're hearing your opponents in court pretty much attack your integrity and your ethics by alleging that we're conspiring together as a defense team to obstruct justice. So, I mean, it was very serious.
A lot of us have the experience of being in court and feeling like the judge is just another prosecutor, and it's us, that we're the only thing between our clients and everyone else. It sounds like that's really what you guys had times 10, because you were being threatened. Well, your integrity was being attacked, and you were being threatened with arrest, and you had to hire your own counsel. What else was there that before you do finally get to withdraw? Anything else that's happening during that time frame?
Well, we've withdrawn by this time, and so all of this is happening. The judge took the position that even though I wasn't there and there was no learned counsel, that the hearings could continue. And so the one remaining lawyer was a very young military lawyer who had never tried, he'd only been on the case, I think 6 months. Really had very little background in homicide defense, much less anything of this magnitude. So he was there by himself and properly took the position that he couldn't do anything because there was no learned counsel, and he was.
Was he not allowed to withdraw because he was military? Was he living under different rules?
They were under different rules, and so he was under he went to the Navy. He was a Navy lawyer. And the Navy took the position that it wasn't going to give him ethical advice. And he felt under those circumstances, he had to remain on the case. And so, at least from my perspective, we're watching these hearings unfold. I mean, I'm on the mainland, just sort of following them as best I can. And the judge is excoriating Rosa and Mary and I, calling us all kinds of names, suggesting that the Department of Justice should investigate our bills, or at least my bills, you know, all kinds of stuff, telling the client we had abandoned him without ever, the client has no idea really what's going on. And it was incredibly difficult to watch. And at the same time, from my perspective, the judge is, well, I can't arrest Cameron. He's got this federal court order, but I can sure as hell try to arrest Spears and Eliadis. And so he would make noises like he was going to issue warrants. He never did, but I mean, every month, as Rosa said, they would absolutely be on. I don't even know how to describe what it must have been like. And so, again, because we were removed, we were removed physically, we were not there. We were having to endure this sort of secondhand, knowing that, this lawyer was being terribly abused. And then the chief defense counsel, who I have enormous respect for. I mean, his career was really threatened over this, and he basically stood up for us. And a lot of military lawyers would have said, well, Judge, if you order me, okay, I'll rescind the order, which would have changed everything. So it was enormously brave. And I certainly felt, and I'm sure Rosa did too, enormous responsibility, both to the others and to General Baker, and to the young lawyer whose name was Ulrich Piet, because essentially this was a fight that largely I had picked, because as learned counsel, I was, at least under the statute, indispensable. So we saw this as an appropriate thing to do, but it was really hard.
I want to talk to you both a little bit about just defending people that can put a lot of pressure on you as lawyers, because you're defending people that are accused terrorists. Does it put you in the line of fire of the biases and the prejudices that people have? Because most people can't hear the presumption of innocence in the same sentence with a terrorist. And so it makes it very difficult, I would imagine, to be a lawyer for that individual.
My experience was really positive. When I first got involved in the case, there was a big article about it in the Indianapolis newspaper. It was sort of a big deal. And I had a number of people who quite conservative, not just lawyers, but people out in the community who were very, very supportive. I had a few people say things, but largely, it was, well, I understand why you're doing this, but boy, I sure wish you wouldn't. But by and large, my experience was quite positive, at least from the rank and file. Now, I didn't read Twitter. I don't think there was Twitter at that time. I didn't read a lot of the stuff. And so there may have been stuff that I wasn't aware of. But like I said,
stay away from the attacks on social media would be smart.
Yeah, I mean, and it was less of an issue than it would have been now. But my experiences up until and even after we withdrew, I got a lot of support from the bar throughout the United States, and I think Rosa and Mary did as well. And so I didn't suffer in the same way that you might suspect.
Rosa, how about you? You have anything to add?
Not really. I think our defense community was supportive because most people are aware of the system in Guantanamo. So,
and many don't support the system in Guantanamo.
Right.
I mean, it speaks volumes that, Rick, you were on that case for 10 years and now this man doesn't have a lawyer or has this kid with 6 months experience and the judge decides he doesn't need learned counsel. Is that what you said? Well,
he decided that he was going to go ahead and he did. He had 3 months hearings there, worked sort of at a week, a month. So he had hearings in November, December, and I think January before everything finally blew up. Yeah, and they were calling, it was pre-trial hearings in which they were calling witnesses, and actually one major hearing took place and one of the government's main witnesses was being deposed before he was going to go back to Saudi Arabia and not be available. And we withdrew after his direct examination. And so essentially the cross-examination was waived, or the judge took the position we were waiving cross-examination, which had that been upheld would have really hurt our client.
Did anyone ever tell the client you guys did not abandon him? Has anybody been able to do that for you?
Well, I was able last year because the appellate process, I mean, the government challenged our withdrawal, and it was not finally confirmed that we were no longer his lawyers until I think it was April of 2019. And so from the fall of 17 till for about a year and a half, we were on varying degrees of are we, aren't we. One of the intermediate military appellate courts ruled that I was still learned counsel, and Rosa was still on the case. Ultimately in 2019, we were vindicated, and somebody's been hired to replace me, and so I have been aiding in the transition. And as part of that, I went to Guantanamo last year and met with our client.
Good. So he was able to hear from you, which is good.
Yeah, and I'm relatively certain he knew by that time exactly what had happened. I don't know the details of that. I mean, I just assumed that. But it was very good for me, and I hope for him, to be able to see him last year and really sit down and explain to him, again, within the confines of classification, what had occurred and why we had done what we did. And he certainly understood that we had taken a lot of risks to on his behalf. I don't
Well,
think
you guys have both talked about that there was a blow up and that the judge was compromised. Rosa, let's start with you. What exactly was happening that the judge was compromised and that there was some big blow up? Other than you guys just getting to withdraw and how that being threatened with arrest constantly, there's more to the story, right?
much.
We found out by accident, so to speak, after we did withdraw from the case and the hearings were proceeding. Eventually, I think in February, the judge abated the proceedings. And sometime thereafter, Captain Miser was reappointed onto the case and basically taken, activated back into duty and made to come and represent Mr. Sherry. And sometime in that time frame, it was unraveled that Judge Thad had been seeking employment with the Department of Justice and as an immigration judge. So
because he wanted to work for the Department of Justice, he was compromised as a fair and impartial jurist in your case?
Yeah, because the Department of Justice essentially represents the prosecution.
Right.
Now, yes, it is the Secretary of Defense. It is under the Department of Defense, but at the same time, they work together with the Department of Justice. So, and that was spelled out in the opinion that eventually came out of the DC Circuit in April of 2019.
What's the name of that opinion for those who want to look it up?
Oh, it's in Ray Nishiri, and
I have it here. I can type it in. I printed it when you sent it to me.
It's in Ray Eliadis too, isn't it?
well, it was, what we did is myself and Ms. Spears also filed to join in the writ.
Spears and Eliadis are listed as petitioners along with Nashir.
Yeah.
Well, Rosa, you and I had talked recently that when this came out, you had been through hell with this judge attacking your integrity, threatening arrest, the prosecution doing the same thing in court. And then this case came out and you felt vindicated, and Rick said earlier that you were vindicated. Say a little bit about that.
Well, it's very rare, I think, that you can have a court with such authority, the DC Circuit Court, come out with an opinion where I feel like the principles we really believe in, the things that we fight for as criminal defense lawyers, sometimes they're getting lost in the courtroom. But it seems like in this opinion, they brought us back to the concept of criminal justice. And the opinion reminded us of, the bedrocks of what we do. Criminal justice, it said, was an obligation of all the participants, from the lawyers to the prosecution and to the judge. That's an obligation that we all bear in a criminal proceeding. So
nice to see that in black and white, because prosecutors and judges seem to forget this sometimes.
Right. And, to see that, and even, there were reticent to say, we don't want to be the ones to remind you, but here we go. This is an obligation we all have in a courtroom to seek justice. So I think having any part of an opinion that reaffirms those values was just pure vindication. And it did go on and say, you know, nobody understood that obligation except for the defense lawyers. So
Wow, that's a powerful statement from the DC Court of, or District, is it District Court, DC District Court?
Circuit Court.
Circuit Court.
Circuit Court. So
I'll tell you that there was a quote in here that I absolutely loved. Unbiased, impartial adjudicators are the cornerstone of any system of justice worthy of the label. That was the beginning of a paragraph, which gives you the, I think they felt very, from reading this case, you feel like they really understood that the judge and the prosecution were not unbiased, not impartial, and criminal justice was not what they were seeking. And you guys, it's wonderful to hear that the court said you guys were. Specifically you and Mary Spears, because Rick, you weren't named in this case, I don't believe.
Right.
right. Well, it alluded to the defense, who's the defense lawyers too. So
Yeah, my name's all over the opinion.
I'm sure your name named a lot. I know you guys were in the media. Rosa, you and I recently talked about how there was a time when you were having to follow Twitter to know if you were going to be ordered to be arrested. Speak about that. I can't even imagine that that's how you're having to monitor your future.
Well, right, because we withdrew at that point. So we weren't part of the case. We weren't down, we were getting our updates through Carol Rosensberg's Twitter feed.
And who is she?
She, at that time, was a reporter for the Miami Herald, and now she's with the New York Times. So she's been following what's all of the cases in Guantanamo since day one.
And so she's updating her Twitter feed with what's happening in court, including threats of contempt and arrest. And that's how you're learning what's happening, because you've already been withdrawn and you're not there?
In essence, yeah. I mean, that's how we get our information.
That's true.
These hearings, they're public hearings. They're supposed to be public hearings, but they're only televised to remote locations where you have to have permission to go. But they do allow media there to report on unclassified proceedings. So yeah. But it's just one more aspect of how it's so different. The experience is not unlike anything you will ever have as a criminal defense lawyer.
And you're still there with the Department of Justice or Department of Defense.
It's fascinating work. It really is.
So Rick, you had used the phrase, the big blow up that was coming. Have we talked about that yet?
Well, a little bit, but what happened in February, and again, I'm following this on Carol Rosenberg's Twitter feed, but also the Ulrich, the lawyer, called me. Is the judge takes the bench, and essentially it looks like he's having this existential confrontation, because he says, you know, essentially the defense lawyers are mean to me, and Kamen and Eliadis and Spears won't come to court, and you know, nobody will listen to me, and my whole faith in military justice is shaken, and so I'm abating the proceedings until some other court tells me to resume. And at the time, it looked like he was just having a complete meltdown. And in fact, a friend of mine who calls me and he says, "This has got to be the proudest day of your life." And I said, "Why that? Why is that?" He says, "Well, I've seen you drive countless prosecutors crazy, but now you got a judge." Well, it turns out, and we learned this later through the work that the defense did on this appeal, that the night before he had accepted employment with the Department of Justice and had arrived at a start date. And so the whole meltdown, cry decor, you know, it was all an act. It was all a show, which ultimately the DC Circuit alludes to. But the government worked very hard to keep that secret. I mean, they knew he had applied. They knew he had been negotiating for over 2 years. I mean, really, as Rosa said, from 2015 on till for 2 years, he was in negotiations with one of the litigants for a job. And, you know, the Department of the prosecution on the appeal, when this came up, said there's nothing, you know, they wouldn't provide discovery. They said there's nothing to this. Ultimately, it came out through a Freedom of Information request from Carol Rosenberg. And they essentially took the position throughout the litigation that there was nothing, no problem here whatsoever, which led, of course, to the paragraph that Rosa alluded to. So that was the blow up, where the case finally stopped and moved to first what's called the Court of Military Commissions Review, and then ultimately to the DC Circuit Court of Appeals. But it was all an act. It was all fraudulent. And it ultimately, one of the, besides our vindication, one of the consequences was the DC Circuit struck all of his rulings from November of 2015 until essentially the case stopped. So essentially, there were 2 years of litigation that evaporated because of his misconduct.
Wow. Where is he now?
He isn't, the job he wanted was as an immigration judge. So he's retired from the Air Force, drawing an Air Force pension, and he's an immigration judge in, I think, Alexandria, Virginia. So he's, you know, got two government incomes, which is what it was all about.
And wreaking havoc over our immigrants who are fighting to stay here.
I am sure.
I'm going to take this moment as a pause, a check-in. Everybody say here. I have 48 attendees. I need y'all to say here at this time. The rules, Rosa and Rick. The rules of how you make sure people are attending and get their full credit. So both of you have, this case is just so full of ethical issues and, you know, biased players who aren't being impartial. And it was discovered, thank God. I can't even imagine how you banged your head against the wall trying to figure out what's going on here, and then, aha, this is what's going on here, that moment. It's not just vindication of your conduct, it's also an explanation for the whole experience. What more do you have to say about that, of how you struggled to figure out what was going on, and then you have that aha moment because finally the truth comes out?
Well, the thing that never made sense to me, when we withdrew, I think we all expected that the judge would say, oh, wait a second. You really want to tell your client? Well, okay, you can tell your client. We'll have some kind of hearing. And had he done that, I think we would have, I think the Chief Defense Counsel would have said, okay, you've got to come back. I think that would have changed the equation. And we were very surprised. I was very surprised that didn't happen. And that instead it just became this incredibly confrontational thing that went on and on and on. And again, it was much, much worse for Rosa and Mary than it was for me. And, you know, at the time, at least I kind of thought, well, he's just a bully, and, you know, he doesn't like it when people say no to him. But when we discovered the details of him seeking employment, it was confirmed that he was seeking employment with DOJ, and then we saw the paperwork and saw the negotiations. At that point, everything made complete sense as to why he was doing it. He was basically lobbying for the job because for example, one of the things he said was, in one of the things he said, well, Kamen says that, or essentially the defense says that there's these microphones, that's just fake news. Well, it wasn't fake news. There were microphones. And that was just lobbying for the job. And that's what that was all about. So in that part, it made a different kind of sense, at least from my perspective. We didn't know when all of that came out, we still didn't know whether we were going to be essentially forced back into the case through the appellate courts or not. That was remained up in the air, but.
Is that up in the air still?
No. The DC Circuit, in the opinion that you referred to, essentially said these guys did exactly what they were supposed to do. And the exact language was everybody it's not the exact language, but paraphrasing, everybody in this process, prosecution, military courts of appeals, the judge, everybody except Nashiri's defense counsel failed in their ethical obligations. So it was complete vindication for Rosa and Mary and I. But as part of that, then it was confirmed that we were no longer Nashiri's lawyers.
One of our attendees has asked a question, not understanding how them, because we don't know who, but somebody bugging the attorney-client meetings forced you guys off the case. And it was because you had an ethical duty to tell your client, but the government was telling you it's classified information and you are not permitted to tell classified information to your client. So it puts you in a quandary with your ethical duty to your client, right?
Exactly. You can't get a knowing waiver you can't tell your client, look, they might be listening. And do you want to continue to meet without being able to tell them, look, they might be listening? You couldn't get a knowing waiver to continue to meet with them.
And as
So the ethical, yes, go ahead, Rosa.
No, as an attorney, we have to take affirmative steps to safeguard the confidentiality. It's not just like we could turn a blind eye. We just have to do something to ensure that. And ultimately, the privilege belongs to the client. He has to make an informed waiver of that. So
I actually know a lawyer here in Missouri who lost his license, and one of the issues that was raised was he was not protecting the attorney-client privilege. He was not advising his client appropriately, and he was having meetings with, well, in this one case, his client and his client's parents, and it was a very serious sex case. I became counsel after the fact, after he got disbarred. But yeah, you guys had a duty and to talk to the client about the privilege.
Right.
And if we don't protect the privilege, the consequences, as I understand them, are we can be forced to testify against our client, or the person in the room who we've allowed to listen to the attorney-client meeting can be forced to testify against our client. Is that the way you guys understand that as well?
Well, there was that for sure, but also the other piece of it was, in this case, we didn't know who. I'm familiar with the Kansas case, and there at least they were able, because they were given discovery and really amazing litigation. They were able to discover who arranged the listening, who benefited from it. That's still a mystery. That's even, here we are 3 years later, and there still has not been the hearing over where these microphones came from and what was done with them. There's other evidence that is classified that we really can't discuss. But to me, my eye makes it very clear that it was most likely the CIA who was listening, because Guantanamo is very much under control of the CIA. But what they were doing with it, who knows? I mean, and, you know, so you have that aspect of it as well. Was the prosecution part of this? I mean, there's just question after question after question that we were obligated to protect, and we had to protect our client.
What's going on in Guantanamo now? Are either one of you still involved at all in any of the litigation there?
Rosa is, for sure.
I wanted to back up and say, you can't have a right to counsel without confidentiality.
Right.
I feel like a lot of this gets lost in, you know, a lot of different details, but if we are lawyers appointed to represent a client and a client cannot communicate with us in confidence, then he does not have a lawyer. I don't know that there's anything that I feel more strongly about as a criminal defense lawyer. And I think that's something that in this system where we are, not everybody takes it as seriously as we do. So.
I agree with you. It's very important that our clients have a confidential communication with us, or you're right, they're not represented by counsel. And there are way too many people, prosecutors and judges included, who don't respect that right.
And I think Rick can tell you he was around when there were some other issues that came up. This wasn't in a vacuum.
Yeah, I mean, this, like I say, Guantanamo is a rather strange thing. Probably from, I would say every 18 months, there was some bizarre issue. Earlier in the litigation, we discovered that in the place where we were meeting with the client at the time, there were smoke detectors, which made no sense because you can't smoke. There was nothing that could catch fire. And so one of the investigators, you know, wrote down the model number of it, and it turns out to be a microphone. But there we were allowed to discuss that with the client, and there was an evidentiary hearing. So I mean, that in that way, it wasn't much of one, and it was probably, we still don't know the truth about that, but at least it passed, from the government's point of view, the straight face test. There was another time where all the defense emails somehow magically migrated to the prosecution's computer server. I mean, so there was just episode after episode after episode where you really question how secret things were.
How did you know your emails were being confiscated?
I think at some point,
email clients, I don't trust the government.
I think at some point somebody in the prosecution said, you guys need to be aware that your emails are on our server. I mean, I think somebody, you know, and it, I mean, that's my memory is how we found out. And then there was a big, how did this happen? And, you know, of course, nobody knew anything, but, you know, and of course, you know, their position was, well, yeah, we haven't read them. I mean, we're telling you that they're there and we've done what we can. But again, it was always in this context of one thing after another. Very early, we have these intelligence analysts who have access to classified websites. And one of our intelligence analysts was doing some research that, you know, in something she was absolutely authorized place to be. And her phone rings and somebody says, I'm, you know, whoever from wherever, and why are you on this website?
Wow.
And her response was, well, because I'm doing my job, and how the hell do you know I'm on this website? And they were clearly monitoring what she was doing and what efforts she were making. And I think in Rosa's case, the case she's working on now, The prosecution has told the defense that if they pursue certain lines of investigation, they, the defense lawyers, are subject to being prosecuted. Because, you know, I mean,
Rosa, can you speak to that? I can't imagine a prosecutor telling me I'm subject to prosecution if I go with that defense.
Well, I prefer not to talk about the ongoing case, but there is litigation over the issue of how to conduct our investigation, and that's
Okay.
as
well, let me just,
in grounds for statements to be suppressed. So yes.
let me help Rosa, because what I know about this is just from what I read on Twitter. One of the issues involved in Guantanamo litigation is torture, because our client, Mr. al-Nashiri, was tortured for 4 years by the CIA. And many of the other defendants who are there in like Rosa's case, they were also tortured. And so one of the things we were pursuing, and I assume they are pursuing, is trying to identify some of the people who were involved in this to interview them, because the information the government has provided is pretty sparse. And at least I read that the government sent the teams in Rosa's case a letter saying, if you continue to try and investigate and identify the people who tortured your client, you will be subject to prosecution under federal law. Now, I don't know, there's probably a lot of litigation that's classified, so there may be more of that, but I know that such a letter was written.
And the journalist's Twitter feed is providing information about this.
Yes.
And it sounds like the investigation is valid, because if your client made a statement under the duress of torture, it sounds like that was the avenue that the litigation was going down, and they're threatening them with, you can't go there, essentially.
Yeah. Yes. Now, we never got there in Nashiri because everything blew up because we quit. But when the case resumes, I'm sure that will come up in the Nashiri case as well. I mean, the torture impacts all of the Guantanamo cases.
How many men and women are defendants in Guantanamo, or how many cases are there? Hundreds or less?
No. 8.
Okay.
Is that right, Rosa? There's 5 in Rosa's case, the 9/11 case. The Nashiri case is 1. There's 1 other, so there's 7, and then I think there may be another that's floating around in some respects, but so about 8.
Way fewer than you would guess.
Yeah.
So
Yeah, fewer than I anticipated.
Yeah.
Well, we are coming to the end of our hour. I want to open it up for questions. You're free to ask questions during anyone's presentation by typing in the Q&A. Just click on the bottom of your screen, there's a Q&A, and you can type a question. We had one earlier. We don't have any now. Give everybody just a couple seconds. You guys have any closing statements of your experience? Any words of wisdom to share?
Well,
I like Rick's sentiment, by the way. I pissed off a lot of prosecutors along the way, and now I got a judge too. And a lot of us public defenders will raise a flag to that. That's been I have the experience of pissing off prosecutors and judges myself.
for me, I mean, you know, we talk about how we defend the Constitution.
Right.
And we do. But I think I never felt it more clearly than in the 10 years I was in Guantanamo. And I've been blessed with a lot of opportunities as a lawyer, but the opportunity to be part of that was for me a real blessing. And Rose and I talked yesterday, and I mean, there's a part of me that misses it terribly. you know, but it was I mean, it was interesting, it was challenging, it was frustrating. But at the end of the day, we were doing what lawyers, American lawyers should be doing. And I was really proud to do that.
Thank you. And thank you. It's really like a service that you did that. We all are fighting the Constitution and defending the Constitution every day. Rosa, any final words of wisdom? We have no questions.
I think it's important to realize that every little battle on a case is important. Even though we get a little jaded as we keep fighting uphill, but I think I've learned throughout my almost 5 years now, you don't know what's going to unravel. And in this case, we had no idea what we would unravel. Had we given up on this issue, none of this would have come to light. And as the opinion talks about, I mean, none of this matters if we don't have a fair system. So I think that's one thing I've learned. And it's a hard lesson. We go uphill every day as defense lawyers, and we're tired of pushing that boulder up the hill, but you got to keep going. So
thank you. Thank you both. And just so you know, in the comments, several people are saying the same thing. Thank you. And we're proud of you. And this has been very helpful information for all of us. And it's also, I don't know why, but sometimes I think it's because of COVID and being forced away from the things that I used to do for fun and joy and relaxation, that I need to be re-inspired sometimes. And your guys' fight and your story and how you took on the government, it's inspirational. So thank you.
Thank you.
thank you, Kim.
I love you both, as you know.
Love you too.